In most jurisdictions, the personal information protected by law refers to personal identifiable information, PII, such as your ID number, your passport number, your cell phone number, etc. In addition to this PII, Chinese law extends this personal information protected by law to also information relating to persons' activities. To just give you an example, I drove to office this morning and GPS information during the route from my home to office is my personal information protected by law. And also if I stop, bought a coffee, the activity of buying a coffee is also a personal information protected by law. So in short, Chinese law actually covers two parts of personal information. One part is personal identifiable information, the other is information relating to persons' activities. I know this question is confusing. Under the CSL, China Cybersecurity Law, it's very clear that only CIIO, Critical Information Infrastructure Operator, has this type of obligation. Whatever personal information or important data this CIIO collects or generates in China in the course of their business operation should be stored in China. However, last May, CAC, Cyberspace Administration of China, published an exposure draft, which is very aggressive, extends this obligation to all network operators. Later on, there were some unofficially confirmed internal discussion drafts. Some of the drafts taking out these obligations from these ordinary network operators. Some versions put them back. So we are not sure whether this ordinary networker has this type of obligation to store all this personal information or important data they collected or generated in China, locally in China. That's kind of why the CSL, a lot of people complain it's kind of murky. There is also exposure draft, again, exposure draft. Puts certain criterion on determining the CIO. Basically, it's kind of consequence test. If any incident happened to the information system of a network operator and some certain consequences incurred, for example, we're endangering the public interest, national security, etc., and this type of companies, network operators, will be identified as CIO. But to be very honest, it's really hard to to specify which company is a CIO or not, because the final effective valid regulation hasn't come out yet. If any CIO violates these local data storage obligations, possible consequences include rectification. The competent authority will first give a chance for the CIO to make a self-rectifications. If failed, the CIO may be imposed a fine ranging from 50,000 RMB to 500,000 RMB. And in the worst case scenario, the CIO may be suspend its business operation, shutting down website, or even revoke its business license. Furthermore, one of the special feature of CSL is that CSL imposes so-called double penalty. Means the penalty will not be only applies to the company itself, network operator, will also applies to individuals responsible in this company. Keep close eye on the legislation, law enforcement, and also complete internal control policies. The difference between a company and network operator has implemented internal control policy or not will will lead to different results in case of any violation of CSL. In short, if a network operator has its so-called ICP, internal control policy, in place, in case of any incidents or violation of CSL, the company itself may have some so-called defense that I have my own ICP in place. And the person in charge, as I mentioned, for example, CIO, Chief Information Officer, may be exempted from liability. Without this ICP, the violation will be deemed as kind of very grave and maybe some intentional violation of law.